morning, Miss Belgrano.
Good morning, your ladyships. Good morning, my lord. I'll be dealing with grounds 8 to 10 with the court's permission today. So if I could go straight to ground 8, please. That's section 102 property issue. It's dealt with at paragraphs 41 to 44 of the revenue skeleton argument. And on this issue and the other issues, I take it as read and I adopt my skeleton argument. The purpose of this scheme, of course, was to remove the value of property from Mrs Elborne's estate for inheritance tax, whilst enabling her nonetheless to continue living there, rent-free until her death. That's precisely the sort of situation that 102 is intended, to which 102 is intended to apply. The revenue's position, and I'll make this good on the text, of course, is that to the extent that the full value of the property, the beneficial interest in the house that was transferred to the life trustees, is not included in the deemed transfer of value immediately before Mrs Elborne's death, Section 102 adds it to the value of her estate for the purposes of that deemed transfer of value. And the court will recall, we'll go back to 102 of course today, but the court will recall that 102 takes effect immediately before death. That's what the deeming is there to do. It's dealing with that deemed transfer of value that we're going to look at in Section 4, read with Section 4 of the Inheritance Tax Act, that talks about what the value transferred is, and the answer is the value is what is in the estate under Section 5. There's therefore, of course, an interaction with what this court decides on previous issues that my learned leader has dealt with. So, for example, if the full value of the property is already in Mrs Elborne's estate because there's no deduction, say, for example, under Section 103, then when we get to 102 and it asks that important question, to what extent is it being transferred as part of the transfer of value, the answer is fully. So there's nothing else for 102 to bring in. So the court will please bear that in mind when it comes to 102. It applies at the end, as it were. What facts do I rely on? First, that as part of a single scheme comprising a number of elements, Mrs Elborne did various things. She entered into an agreement, the sale agreement, the 27th of November 2003 agreement that we saw yesterday, that provided that she would sell and the trustees would buy the property for a purchase price of 1.8 million. We saw that was to be satisfied by the issue of a loan note. Mrs Elborne, I don't think this was referred to yesterday, she offered to meet any stamp duty liability which might be incurred by the trustees. We can get that from the trustees' resolution, supplementary bundle, tab 6, page 44. The loan note was worth no more than £583,500 on the date of issue, considerably less than the nominal value of the note or the market value. FTT decision, paragraph 16. Also as part of the pre-planned steps in the scheme, and just to give the court my submission on 102, one of the issues will be, did Mrs Elborne dispose of property by way of gift? This is why I am going on to, and I am not stopping at, the sale agreement, because I say, when this court asks itself for the purposes of 102 sub 1, was there a disposal of property by way of gift? All the facts should be looked at in the round. That's McGuckian, that's Ramsey, in this sort of a scheme. So as part of the pre-planned steps in the scheme, Mrs Elborne would and did give away the loan note to the family trustees a short time after, and we've heard from the documents it seems to have been intended that would have been the 8th of December 2003. Due to implementation, that was more like January or February 2004, FTT 27, paragraph 27 of the FTT decision. The family trust principal beneficiaries were Mrs Elborne's children. So what happens, of course, on Mrs Elborne's death is that there is an identity, that the beneficiaries under the life trust, which is the holding the loan note as debtor in that sense, and the creditor are exactly the same. And indeed, that is the context for the question that was put to Mr Dumont counsel by Mr Wolfe after Mrs Elborne's death. Can the loan note now be forgiven, given that the beneficiaries of the two trusts are identical? That's recorded in the FTT decision at paragraph 15, subparagraph 18. But of course we know that the beneficial ownership transferred to the life trustees, that was what the FTT held, and that wasn't appealed, and there was a short exchange about that yesterday. So please, with that short background in mind, may we turn straight to the legislation, which is at Authorities, Bundle, tab 8, page 50. So I'll take the court through this, and in doing so I will just highlight the points at issue. So 102, subject to subsections 5 and 6 below, which are not relevant to us. This section applies where, on or after the 18th of March 1986, an individual disposes of any property by way of gift, and that's issue 1. My learned friend says there's no disposal by way of gift because the effect of section 49 is she can't make a gift to herself. I say there was a real-world disposal by way of gift. Nothing in section 49 deems that not to have happened. And that misconstrues the section, which perfectly well accepts that property disposed of by way of gift may actually be within the donor's estate, as it happens, to some or all extent. So that's issue 1. Carrying on, either possession and enjoyment of the property is not bona fide assumed by the donee at or before the beginning of the relevant period, or at any time in the relevant period, the property is not enjoyed to the exclusion or virtually to the exclusion of the donor and any benefit by him by contract or otherwise. And relevant period means a period ending on the date of the donor's death and beginning 7 years before, for our purposes. There is no issue on that. My learned friend concedes that 102(1)(b) is met in the revenue's favour, as it were. It was not enjoyed to the entire exclusion. That's obviously right. She lived there. She had an interest in possession. The property was not enjoyed to her entire exclusion. I should say the FTT also found that 102(1)(a) was satisfied. That is at paragraph 147, subparagraph 2 of its decision. I have 2 points to make. First, that's academic. I don't need to satisfy 102(1)(a). But second, the revenue don't support the reasoning of the FTT on that point. And putting the point very shortly, the FTT says, well, because Mrs. Elborne's interest in the property was exactly the same before and after the disposal by way of gift. Why was it the same? Because she was beneficially entitled to it before as an owner. She was beneficially entitled to it after because of section 49. Therefore, nothing's changed. Therefore, the trustees never assumed possession and enjoyment of it because it was always her. The UT held that reasoning, although the UT doesn't deal with gift expressly because it didn't need to, because it had already found against the revenue on 102 sub 3, the revenue doesn't deal with that reasoning expressly in the context of 102 property, ground 8, but it does deal with it in the context of note, and my learned leader, Mr. Davey, took the court to that yesterday. It was paragraph 191 of the Upper Tribunal's decision, where the Upper Tribunal held that comparable reasoning involved an error of law because it didn't have regard to the capacities in which Mrs. Elborne occupied. And so that's the reason I don't support 102(1)(a), but as I say, I don't need it.
Is the property that we're looking at the house or the loan note?
In 102, my lady?
Yes.
We are looking at the house for the purposes of ground 8.
Right. So how do you get round the fact that the house is sold? How can that be a disposal by way of gift?
2 answers. First, it was sold at an undervalue, and I say that does give colour to what's happening. But the second answer is the one I started with, which is The sale is only one step in a scheme. What Mrs Elborne does is she sells for approximately 33% of the value, knowing full well and then following on with giving that value away to the family trust.
But it's a sale. It's not a gift. I mean, a gift and a sale are very different things. If it were a sham, that's one thing, pretending to sell it when in fact you're giving it away, but that's not being found. There is proper consideration given, whether it's at an undervalue or not. And to my mind, a transaction where one person gives property to another in return for consideration of value is a sale and not a gift. So you fall at the first hurdle. It can't possibly be a gift.
I take my lady's point, but even my learned friend accepts that a gift at an undervalue, I think he still accepts, he did in the FTT, a gift at undervalue. A sale at undervalue, I'm grateful. A sale at undervalue involves an element of gift. He says it's of the undervalue. I say that's not right, it's the whole thing on our facts. But the point my lady's putting to me, which is, well, how can it be a gift if some consideration comes the other way? I'll take the court to Worrell's case. The court looked at it yesterday, but not the passages that deal with whether there was a gift. But if the court recalls, in Worrell's case, there was consideration in some senses coming the other way, because father gifts mortgage, as it were, value of mortgage to son. Son says, okay, I covenant to pay an annuity. What was being argued was that's not a gift, I think possibly very faintly, or at least it's only a gift. You've got to give credit for the consideration coming back. It's not a gift to that extent. And the court says no. Looking at the substance of it, that was a gift. So in my submission, the fact that consideration moves the other way doesn't inevitably mean this court has to conclude sale, not gift. But I say, on the basis of Ramsey, UBS, Rossendale, this court can't stop at the sale agreement in asking whether there's been a disposal by way of gift when we are applying 102 sub 1 at the date of death. And this court does have to look at the rest of the steps in the scheme. So coming then to subparagraph 3 in 102, if immediately before the death of the donor there's any property which in relation to him is property subject to a reservation, which we have, subject to gift, then to the extent that the property would not, apart from this section, form part of the donor's estate immediately before his death, that property shall be treated for the purposes of the 1984 Act as property to which he was beneficially entitled immediately before his death. Two issues on 102.3. The first issue is, does it apply at all in circumstances where Section 49 applies and she's treated as having an interest in possession and settled property? I say yes, because what this section is asking, in the context of the deemed transfer of value immediately before Mrs. Elborne's death, when what is transferred is her estate, what it is asking us is, to what extent is the full value of that gifted property there? To what extent? And my answer is, if its value is reduced by the loan note, it's not. To that extent, it's not. That's issue one, and then on subparagraph 3. And then issue 2, my learned friend says, well, even if I'm right on that, even if the revenue are right on that, he gets a deduction for the value of either the trustees' lien or the loan note. I think at this stage he's saying trustees' lien, but either which way, he gets a deduction under subsection 3, to which I say, no, he doesn't, because this section is concerned with property disposed of by way of gift, and neither the trustees' lien nor the loan note answer to that description for the purposes of ground 8, so he doesn't get a deduction. do 102 sub 3.
So could you just set out for me, Ms Margrano, how you say this works step by step in relation to section 102?
Yes.
Property goes from Mrs Elborne to the life trustees.
Mrs Elborne disposes of the house by way of gift to the life trustees.
Well, let's take out by way of gift.
Okay.
She disposed of it.
Yes.
To the life trustees.
Yes.
You say that is a gift to the extent that.
I say it's completely a gift.
Completely a gift.
I don't
And it's
renounce.
completely a gift because one looks at it in the realm of the scheme as a whole.
That's right. So one does take account that there is an undervalue, which is important. She purports to sell a house worth £1.8 million and gets back something that's worth no more than 500,000. So that's colour number one. Colour number two is everyone knows that she's going to give even that away. What has she done standing in her shoes? She's made a gift.
Okay. That's very helpful, yeah. And then, just if you play that through in relation to subsection 3.
Yes. So then we apply section 49, we apply section 103, and we're obviously immediately before her death. And maybe if I could just show the court, it's at tab 7, the authorities bundle. Sorry. And if we look first at section 4, it's on page 25 of the... Mm-hmm. On the death of any person, tax shall be charged as if immediately before his death he had made a transfer of value and the value transferred by it had been equal to the value of his estate immediately before death. Why am I starting there? I'm starting there because in my submission, the context in which 102 is applying helps this court to understand and construe the section. And if I need authority for that proposition, I find it in the case of O, paragraph 29, Lord Hodge. So, we're at a place where we're immediately before the death. We are focusing on a transfer of value. We know that what is being transferred is the value of her estate. And then going down to section 5, of course, 5 sub 1, a person's estate is the aggregate of all the property to which he is beneficially entitled, and linking that then to 49, which is on page 28, a person beneficially entitled to an interest in possession in settled property shall be treated, for the purposes of this Act, which includes FA 1986, as beneficially entitled to the property in which the interest subsists.
Yep.
So we're in a value world. We are asking about estate, we are asking about interest in possession and section 49, but while section 49 applies not just immediately before death, it applies from the time it applies from...
Flows on.
Flows on. My section doesn't, 102 doesn't. It's applying for a very specific purpose, on death, for that deemed transfer of value. So when we get to the words in subsection 3, if immediately before death of the donor there's any property which in relation to him is property subject to a reservation, and just pausing there, we know from Ingram property is not necessarily just a house, it's a right or an interest, it's a legal construct. Then, to the extent that the property wouldn't form part of the estate. My submission is this court has to give meaning to those words. How does one measure to the extent? This section is expressly envisaging, it's not a dichotomy. It's not the properties is in because of section 49, or it's not in because section 49 doesn't apply and nothing else does. It's asking more than that. To what extent? And so in my submission, what meaning should be given to extent? I say it takes colour from its context. And our context is a deemed transfer of value where property in the estate to which is deemed to be beneficially entitled is being transferred. That's the value that we're interested in that's being transferred by the transfer of value. So that word, to the extent, asks you, is the full value of that gifted property there? If it's not, 102 tops it up. Does that answer my lady's question?
I'm very grateful.
So moving then to issue 1, and we've covered some of the ground already, so I will try not to take the court's indulgence too far. The FTT dealt with this for the court's note at paragraphs 130 to 148, but the court also, please, will need to bear in mind what the FTT says at paragraph 127, which is in a different section, but explains what the FTT says at 146. The UT deals with the property issues at paragraphs 71 to 117, but having decided that 102 subsection 3 had nothing to apply to because of section 49, it doesn't actually deal with the other issues. So we won't find a discussion of gift, we won't find a discussion of 102A, we won't find a discussion of election. That's paragraph 116 of the UT decision. So turning then to issue 1, did Mrs Elborne dispose of her beneficial interest in the property by way of gift? I've made my submission that this court, I submit, should consider the transfer in the context of the overall scheme. So simply, with the court's permission, going to give the references to the authorities that I say make that good. It's Ramsey, page 3238 to 324A of the report. My learned leader took the court to this yesterday. That's the part that says it's the task of the court to ascertain the legal nature of any transaction to which it sought to attach a tax or tax consequence, and if that emerges from a series or combination of transactions intended to operate as such, it's that series or combination which may be regarded. Authorities Bundle, tab 23, pages 258 to 9. Rossendale, paragraphs 12 to 14 and 17. Authorities Bundles, tab 42, pages 762 to 763. And I'm sorry, I'm missing the page reference for the next one. The court was taken to that yesterday. That's the one that said 12 says it's permissible and necessary to consider the scheme as a whole. And then 17 says look at the facts in the round. McGuckian, Authorities, tab 27 at page 408. The court asserts the power to examine the substance of the composite transaction at page 1000 F to H, Lord Stain. Also UBS at paragraph 62, that's Authorities Bundle 38, page 687. That's Lord Reed. Since the facts concerned a composite transaction forming a commercial unity, with the consequence that the commercial significance of what had occurred could only be determined by considering the transaction as a whole, the statute was construed as referring to the effect of that composite transaction. So that was my submission. Those are the authorities I rely on in order to make the submission that one looks at this in the round. And just to show the court Worrell very briefly, that's at Authorities, tab 12, page 89. So as I say, the court has seen this, and my learned leader took the court to this on trenching yesterday, but it was just a few other passages I wanted to show the court. If we pick up the Master of the Rolls, please, which is page 94 of the bundle. And if we pick it up, it's just towards the bottom of the page, the father being entitled to the mortgage debt. If the court might read there to the first hole punch on the following page, please. And then if we pick it up between the hole punches, there's a sentence beginning, the law being that, for this purpose, we are to look to the truth or substance of the transaction. Does this transaction, so regarded, come within the statutes relied on by the Crown? I think it comes within section 11, which was the predecessor gift with reservation provision of the amending statute. It was, in my opinion, a gift within that enactment. So it was the gift of the mortgage debt, even though purportedly to be made in consideration of the covenant by the son to pay the father the annuity.
Is the overall point, just so to make sure I understand the point you're making, so you stand back and you look at this transaction taken as a whole, and the substance is that Mrs Elborne has given the property to her children. Yes?
Well, she's made a gift into the life trust. The children end up being beneficiaries, so to that extent, yes.
Well, I'm trying to strip away the different elements to look at what in substance you're saying is happening. You're saying in effect, she has brought about a situation in which the children get the property, or a right in the property, if you like, an equitable right in the property. And they, in fact, don't end up, or the trustees don't end up paying for it, because the loan note is effectively cancelled out. Is that the point?
I think I'm standing in her shoes, and I'm saying, has this individual disposed of her house by way of gift? She's purported to sell it in the sense of under the sale agreement, I accept that, at an enormous undervalue to the first trust in which she has an interest in possession, which will then go to her children, full knowing that that small consideration she gets back, she's going to give away to a different trust. I say 102, subsection 102, subsection 1 is an anti-avoidance provision, which is operates in the real world in that sense. And where the donor, I do call her a donor, or where the individual, what she's done is say, here's a house at a gross undervalue, I'm always going to give this away a few days, possibly if the scheme had been implemented more quickly, or weeks later. She's not getting consideration back. She hasn't sold something. She has,
and she's given it away. And that's at the moment where I'm having difficulty with looking at this as a gift. It's one thing to say, well, in substance, what you're doing is transferring property from A to B. B is supposed to be paying you for it, but in fact, because of the way that the whole thing is constructed, no money actually ever arises from B. There's a debt, but it's forgiven, and the whole thing then, in substance, is a gift. I understand that as a concept. Where at the moment I'm having a little difficulty with it is the fact that something does come back and then it's assigned out. It doesn't mean she doesn't get the value. It means that she's now disposing of different property to somebody else. That's where I think it falls down at the moment. But I may
yes.
In order to give something away, you have to have ownership of it first.
Yes.
So, I mean, when she transfers the benefit of the loan note, that presupposes, doesn't it, that she's already the beneficial owner of that.
Of the loan note.
Yeah.
Yes. But I say the second gift gives the gift of the loan note, because it's part of a scheme where we look at all the steps in the round, gives colour to whether what she did at step 1 in transferring the house is, the cases used to use the word bounteous. They sometimes instead say gratuitous. Is it a gratuitous or bounteous transfer from her? Or is it something that's not gratuitous? It's for consideration, it's a sale, it's something other. And that's why I'm using the second gift, which I accept is a second gift of the loan note. But I say, but because we're in a scheme, that tells the court something about the nature of what she's doing at step 1, because step 1 was always going to be followed by step 2. That's why I get to look at step 2.
She was always going to divest herself of it. That was part of the nature of the beast.
She had to, because otherwise the scheme,
wouldn't
I think
work.
even on my learned friends analysis, really wouldn't work.
Mm.
Exactly, and that's why I'm saying this court shouldn't close its eyes to that when asking for 102 sub 1, which, as I say, is an anti-avoidance provision. We're in its world. Is there a gift at stage 1? Yes. Yes, there is. On any, I say, ordinary, realistic view of these facts. She, the individual, never was going to get consideration back. If we call the consideration she got by way of a loan note, she was always going to give away as soon as she could. That's a gift. Lord Justice Lopes, at the bottom of page 95, says one question is, in this case, whether there's a gift of property at all. It's suggested that there was not, because there was a collateral covenant by the son to pay the father an annuity. And over the page, it appears to me that there was no less a gift within the meaning of the Act on that account. And
the only difference there was that there actually was a gift from father to son.
Yes. Of the mortgage. The mortgage. Yes, but
forgiving the mortgage.
Yes, but the point being made was, but not because of this.
Yes, but here the only difference between those circumstances is that actually the first stage in moral was everybody accepted was a gift.
Yes.
That's all I'm saying.
Yes. But that was to meet my Lady Justice Andrews' point that, because if we've got something coming back, then doesn't that immediately force this court to conclude no gift? And my answer is no. So what points does my learned friend take against me? They're at paragraphs 38 to 40 of his skeleton argument. The pith of it is really at 38. He says, well, because she is deemed to be beneficially entitled to the property after the transfer, I'm going to call it, that can't possibly be a gift. I say that proposition really, the proposition my learned friend is really making is that since property is within her deemed estate, if I'm right on gift in the real world, that requires that real world gift to be ignored because it's in her estate, because she's beneficially entitled to it. I say that's wrong. It misconstrues the section because, as we saw, this is back on page 50 of the authorities bundle, section 102, subsection 3 in particular, well accepts that property may be disposed of by way of gift and yet may to some extent be property that forms part of the donor's estate.
Well, would not apart from this section form part of the donor's estate?
Exactly.
Would not apart from this section.
Apart from this section.
Yes.
I read 102 as being there as an anti-avoidance provision to catch something that's not already caught by other provisions. And so if it falls within 49, you don't need to go as far as 102. 102 is really aimed at catching some kind of transaction that would otherwise operate to move property outside the donor's estate, and it brings it back in. Looking at it very simplistically.
2 points, and that's really what the FTT and UT held, my lady.
Yes.
And I say that doesn't give meaning to the words "to the extent." This is not asking is the property in or is the property out. This is operating in the context of a transfer of value, the value being the estate, and to what extent.
I don't think that's the way that the draftsman is using the words "to the extent that." To the extent that is longhand for if. If and to the extent that it's not already in, then it's brought in by this. That's the natural reading of those words. It's not about value or numbers or amounts.
And that's why I started with the opening words of subsection 3. If immediately before the death of a donor. So, my lady, in my respectful submission, that tells the court this is concerned with value to some extent. I am not making a submission that the word property is to be read as value. I am not doing that.
No.
But I am saying with a subsection which opens with the words, if immediately before the death of the donor, ... that is concerned with the transfer of value on death, that is concerned with what value is transferred. And that word extent does take its colour from that context. But the point I was making, which I'll try better. My learned friend says, because this property ends up in her estate by virtue of section 49, there can be no gift within subsection 1. That's his proposition in paragraph 38 of the skeleton. I say that's wrong as a construction of subsection 1. We will come to subsection 3 and we will have the arguments about what's the effect of part of it being in her estate, all of it being in her estate on my learned friend's view and all that. We will have that argument. That is in subsection 3. The fact it's in subsection 3, because you then worry about to what extent is the property part of the donor's estate, you worry about that there. That tells you that the fact that property is in the donor's estate, it might cause all sorts of arguments when one gets to subsection 3, but what it doesn't do is under subsection 1 mean that the section never applies.
So if you took a really simple example, if somebody gives away some property but retains a beneficial interest in it so that they would fall within section 49, it doesn't mean the gift isn't a gift.
Yes.
Is that really the point?
Yes. It is, for subsection 1.
Yes.
And then we get to subsection 3 and we have to wrangle, okay, so what does that mean for 102 sub 3? What does it bring in? What does it not bring in? But I'm saying on 102 subsection 1, which is where my learned friend takes this point, he's not using it to construe sub 3 at the moment. He takes it on subsection 1. He uses it to narrow the concept of disposal by way of gift in subsection 1. And that's what I'm saying is wrong and is inconsistent with how subsection 3 is drafted.
So you say subsection 1 applies in any circumstances where there is a disposal of an interest of land by way of gift, and it doesn't matter whether the consequences of that disposal have ramifications in other parts of the statute.
That's what I say, because subsection 3 will then deal with it.
Right.
and my learned friend relies on Eversden. I'll do this as quickly as I can. I think I'd better just show the court Eversden because he does rely on it. My short submission on Eversden is it does not help this court when construing section 102 subsection 1, because by the time that case reached the Court of Appeal, it was common ground that there was a disposal by way of gift. It was also common ground that that disposal was an exempt transfer from wife to husband. The argument was whether that meant that section 102 subsection 5 applied. And I might actually just do this by reference to subsection 5 because time is moving on and it'll be quicker. So that's page 51 of the authorities bundle, please, and it's tab 8. So this section, being section 102, does not apply if, or as the case may be, to the extent that the disposal of property by way of gift is an exempt transfer. And just pausing there, it was, as I say, it was common ground. The transfer was an exempt transfer because wife puts it into an interest and possession trust for husband who had a life interest. That's an exempt transfer under section 18, which essentially looks at whether the value transferred ends up in the husband's estate. Answer, yes, it did, because of section 49, so it was an exempt transfer. So the question was, given that, does section 102 subsection 5 knock out 102 from applying completely because of what it says in little a? So to the extent the disposal of property is an exempt transfer by virtue of any of the following provisions of the Act, section 18. So as Lord Justice Carnworth, as he then was, says on first blush, yes, if you've got an exempt transfer, everyone agrees it's an exempt transfer, that just knocks out 102 completely. What Eversden is then about is the revenues argument that, but now we've got Ingram. Now we know that the concept of disposal of property by way of gift, when it's into a trust, as it was in Eversden, and under the trust you had, first of all, a life interest for the husband, then you had a trust for a period of about 80 years for settlor and children, and then after that period a trust for her and her child and wider issue. And what the revenue was saying is, that's not one gift, that's properly analysed 3 different gifts, because gift, we know from Ingram, is of interests. So when it's a gift into a trust, you've got to split up the gift. Why does that matter? Because 102 sub 5 only ever attached to part of the gift that went to the husband, his life interest under the trust. By the time the settlor's dead, that's finished, that's no longer there, there's no exemption from 102 at all. So my short submission is, we've looked at Eversden at all levels, my submission remains the same. It might help this court to construe section 102 subsection 5, but it doesn't help this court to construe section 102 subsection 1, which was common ground. So I've taken the court through how I say I've dealt with some of issue 2, which was the construction of 102 subsection 3 as part of my submissions. But I think I'd better just show the court what the FTT said in addition, because in addition to the point that both the FTT and the UT made, which is that because section 49 applies, the property is in the estate, and there's therefore nothing for section 102 sub 3 to bite on. the FTT made a further point, which is, and what's more, that's supported by certain provisions that are found in the pre-owned assets regime. What I think the FTT, and I'm sorry, that is paragraph 146 of the FTT's decision, but it's actually more useful if we want to look at it in paragraph 127 of its decision. We can pick it up from the third line. It's on page 253, I'm sorry. 127. It therefore seems to us to be clear that the deduction of settlement liabilities is a matter which goes to calculating the value of property to which the deceased is to be treated as being beneficially entitled, as opposed to the identification of the property to which the deceased is to be treated as beneficially entitled. We would add further support for that proposition is to be derived from the terms of paragraph 11 of Schedule 15 to the Finance Act 2004, because it's clear from the language in paragraph 11.6 of that schedule that a liability which affects the value at which property is to be brought into account in calculating the value of a person's estate does not prevent the part of the property which does not exceed that liability from being part of that estate, otherwise paragraph 11 sub 6 would not have been needed. The UT actually says that it doesn't read, that's what the FTT says at 127. If we then look at 146, which
That's
is
in the context of Barb Green.
It is in the context of St Barb Green, but in 146, which is in the context of 102 subsection 3, the FTT refers again to 11 sub 1 sub 6 sub 7. Just to give you the coda, just to give the court the coda, the UT thought that the FTT's reference to paragraph 11 here was immaterial to its decision. The UT thought the FTT had actually decided 102 sub 3 on the basis of St Barb Green. That's paragraph 110 of the UT decision. Although the UT said that the language of paragraph 11, which we're about to look at, may potentially be used to show how Parliament understood the existing legislation to operate, that's paragraph 115 of the UT's decision. So just pausing there, the combination of paragraph 127 and 146 of the FTT's decision, what I think that's telling us is the FTT has drawn this bright line distinction between value and the identification of property in an estate. And I think that's the point my Lady Justice Andrews was putting to me earlier. So my response to the FTT is the same as to my lady. That doesn't give the right meaning to the word extent, because it ignores the context in which that word and 102 sub 3 is operating, which is a deemed transfer of value. And it is looking to add value to that deemed transfer. So I suppose I started there to say the first tier tribunal in my submission was looking for support, I say in a wrong place anyway, but for a proposition that I say, if it had construed 102 sub 3 correctly in my submission, it wouldn't have been looking for anyway, because it gives the answer in 102 sub 3. And actually, in my submission, that's a more natural place to look for the answer rather than in the POAC code. But I'll show the court the POAC code on this. That can be found in Authorities Bundle, tab 11, at page 77. And just to put it in context, because if I might take a step back and address the next 40 minutes, I'll give this a bit of an introduction, this POAP code, because it is relevant to ground 10. So if I cover the ground now, then I've dealt with a bit of ground 10 as well. How this all fits together before we get there is my submission as to the relevance of this code is if I'm wrong on section 102 sub 1 that there was a disposal by way of gift, I say that the effect of this code and what's common ground, which Mrs Elborne elected under this code, we'll have a look at the election when we get to ground 10, but she elected. I say the effect of that is to click on section 102 subsection 3 in respect of £1.8 million, whether or not there was a disposal by way of gift. I'll show the court why, but that just to give a, if I'm wrong on there was a disposal by way of gift, in principle section 102 would not apply, and therefore section 102 subsection 3 would not apply. When we come to the election, we will see that what the election says, and if I can put it in my terms, what the election says is, Mrs Elborne, you've got a POAP liability on £1.8 million. I think that's common ground. Absent an election, she would have had a POAP liability. That's an income tax liability, which is applied to former owners of property, land, who continue to, inter alia, occupy the land. What I say the election does is it says, Mrs Elborne, you now have a choice. You can either suffer the POAP charge, which is this income tax charge, or you can elect that section 102 subsection 3 will apply to that 1.8 million. That's the choice. A learned friend says, because of the wording of the election, it's an opt-out from POAP with no consequences at all, that it doesn't click on 102 subsection 3 at all. But so that's why I'm saying the election in ground 10 is relevant if this court is not with me on the construction and application of section 102 subsection 1, because it's held against me that there was no disposal by way of gift. So this legislation, as I've said, it provides for a charge to income tax on benefits received by a former owner of property, and it applies to individuals who continue to receive benefits from certain types of assets, including land. And it's brought in by section 84, which is on page 78, but the meat of it is in schedule 15. So if we turn please to page 79, the charge is in paragraph 3. This paragraph applies where an individual, the chargeable person, occupies any land, whether alone or together, and the disposal or contribution conditions met. Subparagraph 2, the disposal condition is that at any time after 17th March 1986, the chargeable person owned an interest in the relevant land, and then skipping down to B, the chargeable person has disposed of all or part of his interest in the relevant land or the other property, otherwise than by an excluded transaction, and it's common ground. Excluded transactions dealt with in paragraph 10, but it doesn't apply. So subparagraph 5, where this paragraph applies to a person in respect of the whole or part of a year's assessment, an amount equal to the chargeable amount determined under paragraph 4 is to be treated as income of his chargeable to income tax. And just to give the court, I think it's common ground, but anyway, the revenue, say the chargeable amount, I'll show the court why, but is rental value of £1.8 million. Why is that the chargeable amount? The answer is found in paragraph 11, which is on page 84. So paragraph 3, land, that's the charge we've just seen, doesn't apply to a person at any time when his estate, for the purposes of the Inheritance Tax Act, includes the relevant property. So that's the land. So pausing there, one might say, well, she's not subject to POAT because section 49, so that's the end of POAT. But it's not, because subsection 6, subparagraph 6 of paragraph 11 provides, where at any time the value of a person's estate for the purposes of the Inheritance Tax Act is reduced by an excluded liability affecting any property, that property is not to be treated for the purposes of subparagraph 1 or 2 as comprised in his estate, except to the extent that the value of the property exceeds the amount of the excluded liability. Excluded liability is dealt with in subparagraph 7. It's common ground that the note was an excluded liability because the creation of it and the sale, transfer of the house were associated operations.
I thought your case was that her estate isn't reduced by an excluded liability.
That's why I said the timing of when these provisions apply is very important, because is my lady referring to 102 sub 3?
No.
No.
I'm referring to the Revenue's general point that you can't treat the loan note as reducing her estate at all.
That's on death. I believe that submission, certainly where I make that submission is immediately before death.
All right, so for these purposes, you say you can treat her liability as being reduced by an excluded liability. So her estate while she's alive is treated as being reduced, but the minute she dies it isn't.
Yes, I was just reminding myself of the opening words of section 103, which I think is what my lady's referring to. But that also applies immediately before death. So neither 103 nor 102. Let's imagine we're looking at the POAT regime year on year. I think her election was in roughly 2007. Yeah. We can look at it, but this is well before her death, so 2007, 2008, 2009. So it does make, and that's also why I said 102 applies at the end, as it were, because I accept that 103...
I understand all of that. I'm just trying to work out for POAT purposes.
Yes. So for POAT, what we're being told here is POAT, for the purposes of POAT, the £1.8 million is not treated as part of her estate. That's the combination of subparagraph 1 and subparagraph 6.
Because of the loan note.
Because of the loan note. And therefore, there is a POAT charge in respect of the rental value on £1.8 million, because that £1.8 million is not being treated by POAT as within her estate. So it's not protected from POAT.
But why is it 1.8 and not 500,000?
It's not 1.8 and it's not 500,000 and it's 1.8 because
this was 500,000 a moment ago when it was a gift, or when it was to the extent
that. Yes, it's because I was using POAT I'm using it in 2011.
At the earlier stage?
Well, POAT did apply at the earlier stage.
Yeah.
That's right, but I'm not concerned with that stage, because what I'm asking is whether the effect of the election on her death was to bring in 1.8 into section 102 subsection 3. And at that point, it was 1.8.
Okay,
that's fine. Yes, and I'm reminded to say the excluded liability concept is only a POAT concept. It doesn't read into the Inheritance Tax Act. But I think what the FTT was saying was, look, here's an example of a provision that says if your estate is reduced by value of a particular type that we don't like, then that is not treated as being property comprised within the estate. So that's not in section 102 subsection 3. That tells me section 102 subsection 3 is not concerned with value. Otherwise, you'd have seen something like this. And as I said, my submission is that we'll come back to those provisions. But my submission is that section 102 subsection 3 already tells you it's interested in value, and that's just a different. You don't need it. It's a different technique. Parliament could have done it that way, possibly, but it didn't. It did it in a different way. Yeah. Okay. So turning then to the last issue, and I think I can deal with this very briefly indeed, on 102, this is at paragraph 35 of my learned friend's skeleton argument. He says, even if Mrs Elborne was somehow deemed to be beneficially entitled to the property under 102 sub 3 rather than under 49, I obviously don't put it like that myself, but anyway, carrying on, that would make no difference to the question whether the liability under the note could be taken into account in ascertaining the value of the property. The liability would be taken into account either way, and he refers us back to paragraph 9 above, which is where he deals with his trustees lien and all that. 2 points. First of all, interesting, even my learned friend accepts, to some extent at least, that section 102 is concerned with value. He underlines it. Because I think what he's saying is, because this section is concerned with value, I get to say, in working out what I bring in under 103, if I'm right on everything else, which of course he disagrees with, but I get to look at the value of the trustee's lien, or the loan note, or whichever one my learned friend pins himself to.
It has to be looked at somehow in order to work out what you're charging. I mean, your case, as I understand it very simply, is the effect of 102 if it bites, is that the whole of the estate comes in and there's no deduction for the trustee's charges.
If 103 disallows the trustee's charges or the loan note, whichever one, then I say 102 has nothing to bring in. Because then one would ask, is the full value of the gifted property in the estate?
Yes.
And the answer would be yes. So that's right. But the point I'm making is that by trying, my learned friend accepts what I think neither the FTT or the Upper Tribunal accepted, which is 102 is concerned with value to some extent, and I choose my words carefully. And he uses that to say, aha, I get to bring in a deduction for my trustee's lien. I say, no, you don't, because this is concerned with gifted property, and trustee's lien and the note is not gifted property for the purposes of Round 8. So that's my short answer on that. But I wanted to show the court that even my learned friend says we can find value in that. And on the manual, and I should say, I'm very sorry, my learned friend referred to the manual, so it should have been in the bundle. I've brought copies to hand around. My learned friend refers to the Revenues Manual. The reason he does that is because in this manual there's an example. And in the example, a deduction of some description is allowed in respect of a loan that's not been repaid. Basically, it looks as though a deduction has been given for the equivalent of the lien or the note in some way, if one looks at value. It's not a lien or a note. I'll hand it up, but the short point is the revenue accept that is overly generous in the manual. There shouldn't.
Well, they would say that, wouldn't they?
It's not a...
Thank you very much. Thank you.
Thank you. Where shall we put it?
I think there's a tab in the authorities bundle towards the back. There's a tab that includes manuals. I will find the tab.
There.
tab 54.
Thank you.
And there's a collection of manuals, and this should have been in there. Oh, I'm sorry. It's not.
Thank you as well, Rana. That's very
Right. Okay, ground 9.
Yes.
102A. Why is this relevant? This is relevant because the sale agreement was never completed. I say for the purposes of section 102 that doesn't matter. There was still a disposal of property because property is defined in section 272 of the Inheritance Tax Act, which applies for the purposes of 102 by virtue of section 11 of FA 1986. It's a right or interest in property. That's apt to cover what was transferred under the uncompleted agreement for sale. 102A is relied on by the revenue in case we're wrong on that, and that therefore what was disposed of has to be called an interest in land rather than property. But I should make it clear, 102A can only apply if 102 doesn't. So that's in section 102C subsection 7, FA 1986.
So this is a purely alternative ground, is that right?
It is, and neither side is saying that 102 doesn't apply because property wasn't disposed of. So the Upper Tribunal didn't want to hear me on this, I think for that reason. But I say that there are errors in the FTT's, that the UT didn't deal with this, but there are errors in the FTT's decision on this. If we can look at 102A, please, it's in Authorities Bundle, tab 8, page 52. So again, I think given the time, I'll take it short and I'll give the court identify the issues and give the competing views and my response as we go. So this section applies where an individual disposes of an interest in land by way of gift on or after the 9th of March 1999. First issue, is there a disposal by way of gift? So it's exactly the same as what we've had on 102. It's in my learned friend's skeleton. I don't think he takes any different point on 102A as opposed to 102. If I'm wrong on that, I'll deal with it in reply, but I don't think he does. 2, at any time in the relevant period, when the donor or his spouse enjoys a significant right or interest, or is party to a significant arrangement in relation to the land, the interest disposed of is referred to in relation to the gift and the donor as property subject to a reservation, and section 102 sub 3 and 4 above shall apply. So just pausing there, I think in my learned friend's skeleton, he says something like, if he's right on 102 sub 3, that disposes of grounds 9 and 10 as well. That's not quite right. I can win on grounds 9 and 10, but because if I win on grounds 9 and 10, the effect is that 102 sub 3 applies, it doesn't ultimately help me, because if I'm stuck on 102, but it's not quite, with respect to my learned friend, it's not quite right to say it disposes of 9 and 10. 9 and 10, I can perfectly well win on both without winning on 102 sub 3. Because the effect of winning on grounds 9 and 10 is that 102 sub 3 applies, and then this court may or may not say to me, that doesn't help you anyway. But I'm simply making a point that 102 sub 3 doesn't itself hurt me on grounds 9 and 10. Subsection 3 then.
It might render them academic.
It might render them academic. I'm grateful, my lady. So, sorry, before moving to subsection 3, there's an argument as to whether Mrs Elborne was party to a significant arrangement for the purposes of subsection 2. The FTT said she wasn't because what entitled her to occupy the land was her right as an interest in possession beneficiary. And therefore, those words, or as party to a significant arrangement, are not relevant. That's not what she is. She doesn't enjoy a significant she is not party to a significant arrangement in relation to the land, because reading into subparagraph 3, it's not that arrangement which entitles or enables her to occupy all or part of the land. I say that was wrong. She did have, we know she was an interest in possession beneficiary. We saw the trustees' resolution yesterday. We know that she had that right or interest. But I say, echoing Learned Leader's submissions yesterday, this arrangement and her ability, the word used in subsection 3 is enables. She was also enabled to occupy the house as part of the wider arrangement. So all the points that my Learned Leader was making yesterday, that baked into this whole scheme, was that her and her husband were never going to be asked to leave the property. It was part of the whole thing that she would occupy the property. That's what I say the arrangement limb is relevant to. If I'm right on that, then I think that does resolve this issue in my favour, because the only get out would be subsection 4. If there's an arrangement that entitles or enables her to occupy the land, the only get out for her is subsection 4. And my learned friend conceded, I think he said it wasn't in point in the FTT, that's FTT 156. So I think that would be, I would succeed on ground 9. If I'm not right that there's that arrangement, because this court is not with me, that it was anything other than her right or interest as an interest in possession beneficiary, which enabled her to occupy the land, if that's what the court says, then I say, right, well then it's subsection 5 which is important, if we can just look at that. A right or interest is not significant for the purposes of subsection 2 above if it was granted or acquired before the period of 7 years ending with the date of the gift. So I say, in my submission, it should be clear that she did not have that right as an interest in possession beneficiary to occupy the land 7 years before the gift, because the trust didn't exist, the trustees didn't exist, the land hadn't been transferred, nothing of this had happened. So how could that possibly be met? The FTT said it was met, and therefore 102A didn't apply, because she's treated under section 49 as being beneficially entitled to the property. I say that involves an error of law, as the UT identified at 191 in the context of the note issue, because it elides her different interests and capacities. Before the scheme, she was simply the freehold owner. She had the house. After the scheme, she occupied it by virtue of being an interest in possession beneficiary. That is not the same right and interest that she had before. And it's wrong as a matter of general law as well. So if I can just give the court the references, re Salus, it's in the bundle, Authorities, tab 14, page 104. It's a very short judgment that it simply makes the point that the rule in Selby and Alston is where equitable and legal estates, equal and coextensive, unite in the same person, and the former merges, or in other words, a person can't be a trustee for himself. So if I have the entirety of a house, I am not holding as beneficial owner for myself in some way as a trustee. There's no separation of beneficial interest and legal interest in that moment. And we can get the same thing from Lewin. We've got that in the bundle, paragraph 1009, Authorities, tab 59, page 1273. And Lord Brown Wilkinson in Westdeutsche, Authorities.
This is all pretty trite law.
Yes, my lady, it is. But the FTT got it wrong in my submission. So absolutely.
Her interest as an owner is different from her interest, which is created in the property by reason of the fact that there's a trust and she's now got a beneficial interest.
Absolutely.
Two different animals.
Absolutely. And because that interest enables her to occupy the property or gives her a right to occupy the property, that is a significant interest. It was not granted or acquired 7 years before the date of the gift. Subsection 5 does not apply. Subsection 102A, and therefore subsection 102 sub 3 would. Election, 12 minutes. We're back into POAT. Can we pick up, please? It's tab 11. And that is page 84, the authorities, of tab 11, page 84.
Yes.
So, Mrs Elborne, so we've seen paragraph 11, the exemptions from charge. And I've made the point that for the purposes of POAT, Mrs Elborne's estate at the date of death was treated as, the 1.8 million was treated as not being within Mrs Elborne's estate for POAT. That's because that amount was covered by an excluded liability. So the subsection 6, subparagraph 6, the property is not to be treated for the purposes of subparagraph 1 or 2 as comprised in his estate, except to the extent that the value of the property exceeds the amount of the excluded liability. It's a bit convoluted, but what that means is 1.8 million is not treated as within the estate for the purposes of the POAT exemptions. Therefore, in principle, there is a POAT charge in respect of that 1.8 million. And now we go to what is the real fight on this ground 10, which is paragraph 21 on page 86 of the same tab. Election for the application of inheritance tax provisions. This paragraph applies where a person, the chargeable person, that's Mrs Elborne, would, apart from this paragraph, be chargeable under paragraph 3. And we need not read further because that was a relevant paragraph for her. And we can move to subparagraph 2. The chargeable person may elect, in accordance with paragraph 23, that the preceding provisions of this schedule shall not apply to him during the initial year and subsequent years of assessment, by reference to his enjoyment of property, but B, so long as the chargeable person continues to enjoy the relevant property, which she did, or any property which is substituted for the relevant property, the chargeable proportion of the property is to be treated for the purposes of Part 5 of the 1986 Act in relation to the chargeable person as property subject to a reservation, but only so far as the chargeable person is not beneficially entitled to an interest in possession in the property. And then the next bit, section 102 sub 3 of that Act shall apply, but only so far as the chargeable person is not beneficially entitled to an interest in possession in the property. What's the fight? The court will see it. I say the effect of Mrs Elborne having elected, which she did, is that 102 subsection 3 applies to bring in, applies in respect of £1.8 million. Because that was the part that was subject to POAT. She's looked at this election and she said, I prefer not to pay POAT and I'll opt into inheritance tax. And I say the effect of that is in subparagraph 2b Roman 2, 102 sub 3 applies in respect of that 1.8 million.
But she's got a beneficial interest in possession in the property.
So
how can it?
So that's what my learned friend and the FTT say.
Yes.
That section doesn't apply because she's got a beneficial interest in the property.
Yes.
My answer is yes, but we've been told for POAT by paragraph 11, subparagraph 1 and 6, that her estate, she is to be treated as not having that 1.8 million in her estate. POAT wants that. It wants it to be subject to POAT.
It doesn't stop
It's
her
page
having a
84.
beneficial interest. That's apples and pears.
I say, with respect, my lady, it's not. Both the interest in possession idea and what's in your estate idea are part of the same question. What's in your estate? What's already in your estate for IHD, which means that POAT need not apply. POAT's...
But then that becomes circular. I'm sorry, it becomes a completely circular argument, because otherwise there's no point in having the reservation insofar as the chargeable person isn't beneficially entitled. If they're beneficially entitled, you're always going to have Section 49 applying. So it makes no sense. What value do those words have if it doesn't mean what Mr. Bradley says they mean?
My submission is that where we've already been told that we have to pretend that 1.8 million is not in her estate within this schedule, for the purposes of this schedule, which is what we've been told by paragraph 11, that deeming carries across to subparagraph 2 here.
And so because the 1.8 million has been cost out
Yes.
Within this regime,
Yes.
it is something you say in relation to which she's not beneficially
She is
entitled.
equally not treated as being beneficially entitled to an interest in possession in it for the election.
That's quite...
It's
it's quite a stretch on the words.
Well,
Big leap on the
it's-
words, and also I'm still waiting for an answer to my question, which is what is the purpose of... give me an example, please, of a situation in which somebody would be able to rely on the words insofar as the chargeable person is not beneficially entitled to an interest in possession of the property, when this isn't the very situation that we're dealing with.
Well, if they're entitled and for example if they haven't had an excluded liability, so I need to go back to paragraph 11 to answer my lady's question.
Yes.
So if my lady imagines that 11.1, the land is within her estate for the IHT Act, so the land is included.
As a result of Section 49.
Yes. So pausing there, imagine I don't have an excluded liability. Forget excluded liabilities. POAT just doesn't apply, and she would be beneficially entitled to an interest for POAT. So it would dovetail. POAT just wouldn't apply. It carries through to the rest of the Act. I mean, I suppose if it were all in her estate, she wouldn't need to opt out at all. So we need
I'm wondering why she made the election.
She made the election because she would have been within POAT had she not made the election. Because subparagraph 6 of paragraph 11 tells us that she is treated as not having that £1.8 million in her estate. That's why she's got to make an election.
And that's why you say the reference to excluded liability in 11.6 has the effect which you described in relation to beneficially entitled in 21.
Otherwise, the election isn't doing what it's meant to. Because if one reads the election provision fairly in my submission, what it's saying is, I, Parliament, have given you an option. You would have been subject to POAT on that excluded amount. but I'm going to give you an option, and your option is you can opt into 102 sub 3 applying. Then it's a matter for 102 sub 3. I'm not going to say anything about how that applies. That's a problem for it, which is why I say the FTT was wrong anyway to go hunting here in order to work out how to construe 102 sub 3. But I've done that point. But that is an election. And my learned friend says, you know, we need to construe the words that have been used in a purposive way. And I completely agree. But what I'm saying is, having deemed property not to be within your IHT estate, because POAP wants to capture 1.8 million, so it's saying it's not within your estate, it then says, but wait, you can elect so that you don't need to pay POAT. My construction gives that election an actual function as an election, because I say you either pay POAT on that or the deeming carries through, so 102 sub 3 applies. My learned friend treats it as an opt-out, as the FTT did, and the FTT accepted it was an absurd, it reached an absurd outcome. I say that should have been a strong indication it had gone wrong. My learned friend accepted in the FTT that the outcome was absurd. He now rose back and he says it's a bit unfair that I call it absurd. It is absurd. This is an election. Either POAT applies or 102 sub 3 applies. That's my submission as to what the purpose is. And if I could just show the court one more provision then, which is maybe an answer to my Lady Justice Andrews' point. It's paragraph 11, sub-paragraph 11 of the same schedule.
I was looking at that.
Yes, sub-paragraph 12 applies at any time where the relevant property has ceased to be comprised in a person's estate for Inheritance Tax Act, or he's provided consideration for the acquisition. And then it's the next bit in particular I want to focus on. And at any subsequent time, the relevant property or any derived property is comprised in his estate for the purposes of the Inheritance Tax Act as a result of Section 49 of that Act, treatment of interest in possession. Why do I show the court that? Because I say, look, here's an example of the Schedule 15. It knows that the relevance of something being an interest in possession or beneficially entitled to an interest in possession, it knows that the relevance of that is that you are within the IHT estate. It knows that. And that's why I say, when paragraph 11, subparagraph 6 says you're not within the IHT estate to the tune of £1.8 million, that absolutely can carry across in this schedule to the election provision, which equally means you're not treated as being you're equally not treated as being beneficially entitled to an interest in possession. And yes, exactly. And I should say, I'm remind the court that election's only relevant if you're not with me on gift, because as we've seen from paragraph 21, that if I'm right on election, then 102 subsection 3 applies to the £1.8 million, whether or not there's been a disposal by way of gift. If you want to put it another way, it bypasses 102 sub 1. It's 12 o'clock, unless I can assist the court further. Those are my submissions.
Thank you very much, Ms. Prograno. Mr. Bradley.
My ladies, my lord, for the sake of simplicity, I'm going to take the issues in the same order as my learned friends, which means I'll be starting with section 103. There are two questions here, both of which need to be answered in the affirmative for section 103 to apply. First question is, was the liability under the note a debt incurred by Mrs. Elborne? The The second question is, was the consideration for the debt property derived from Mrs. Elborne?
Sorry, so was the liability under the noted debt incurred by Mrs. Elborne?
That's
And
question
secondly,
one. Question two, was the consideration given for that debt property derived from Mrs. Elborne? The debt incurred by question, as my Lady Justice Asplin observed yesterday, is not really to do with the construction of Section 103 itself. That is because it's common ground that Mrs. Elborne did not, in fact, incur the debt. The question is whether she is deemed to have incurred the debt by Section 49. And so it's a question about the construction of Section 49, subsection 1, rather than Section 103 itself. Section 49, subsection 1, provides that a person beneficially entitled to an interest in possession in settled property is treated for the purposes of the Act as beneficially entitled to the property in which the interest subsists. Again, it's common ground that Section 49, subsection 1, does not say that the interest in possession beneficiary is deemed to have incurred liabilities actually incurred by the trustees. And so HMRC's case depends entirely on it being a necessary implication or inevitable consequence of the deeming in Section 49, subsection 1, that the beneficiary is also treated as having incurred the trust liabilities. Now, in order to evaluate a submission of that nature, it may be helpful to look at the authorities which explain what a necessary implication is. And I would please like to refer the court to two, being Morgan Grenfell and Mark McLaren. Morgan Grenfell is Authorities Bundle, tab 29, page 435. This was a case about Section 20 of the Taxes Management Act 1970, as it was then in force. And Section 20 gave an inspector power to require a person to deliver to the inspector documents in that person's possession, which, broadly speaking, contained or might contain information relevant to that person's tax liability. And in purported exercise of that power in Section 20, the inspector required the taxpayer bank to deliver counsel's opinion in respect of the scheme the bank had entered into. And that engaged the principle of legality, because legal professional privilege is a fundamental right, and therefore Parliament is presumed not to intend to abrogate that right unless it says so expressly or by necessary implication. And very broadly, the argument for the revenue in this case was that there were other provisions of the Taxes Management Act 1970 around Section 20 itself that conferred express protection for privileged documents in certain circumstances. And so the argument was, well, that implies that Section 20 was not meant to contain within it a protection for privileged documents. And the House of Lords said that that wasn't good enough. It was debatable whether it was an implication at all, but it certainly wasn't a necessary implication. And the passage which I rely on is in the judgment of Lord Hobhouse, paragraph 45. That's page 488 of the authorities bundle. Paragraph 45. It is accepted that the statute does not contain any express words that abrogate the taxpayer's common law.
It's paragraph 45.
I'm sorry, my lady. This is paragraph 45 of Lord Hobhouse's judgment, which is page 488 of the authorities bundle.
There are two paragraph 45s.
Aha. Yes, thank you.
Well, of course, the report also contains the judgments in the Court of Appeal.
Below, yes.
This is where we were, I'm sorry.
So we want to be here.
Yes, so you were at 45, which is, it is accepted.
It is accepted that the statute does not contain any express words that abrogate the taxpayer's common law right to rely upon legal professional privilege. The question therefore becomes whether there is a necessary implication to that effect. A necessary implication is not the same as a reasonable implication, as was pointed out by Lord Hutton in the minor. A necessary implication is one which necessarily follows from the express provisions of the statute construed in their context. It distinguishes between what it would have been sensible or reasonable for Parliament to have included, or what Parliament would, if it had thought about it, probably have included, and what it is clear that the express language of the statute shows that the statute must have included. A necessary implication is a matter of express language and logic, not interpretation. That is Morgan Grenfell. The decision of the Court of Appeal in Mark McLaren is at tab 45, page 880.
Sorry, just before we go
Yes.
there, did the other members of the House agree expressly with what Lord Hobhouse said there?
No, they're all agreeing with Lord Hoffman,
Lord Hoffman, yes.
who said actually on analysis, I'm not sure this is even an implication at all. Yes.
And Lord Hope, for what it's worth, did actually agree with Lord Hobhouse as well. Paragraph 41.
Yes, great.
I'm sorry, you were taking us to divider.
Mark McLaren, tab 45.
Thank you.
Tab 45, page 880. This was the case about elective proceedings brought in the Competition Appeal Tribunal on an opt-out basis. The defendants had written to a number of businesses who were in the relevant class, explaining that if they didn't opt out, they would automatically be included as claimants in the litigation, and that in that event, the defendants would be requesting disclosure from them. The class representative argued that the defendants were not allowed to do this without the permission of the tribunal. There was nothing in the tribunal rules that said the defendants weren't allowed to do this, but the argument on behalf of the class representative was that it was implicit. And it's in that context that Lord Justice Popplewell sets out the relevant principles at paragraph 42 onwards of his judgment, which is page 897 of the authorities. One at all. So, paragraph 42 simply refers to the decision of the Supreme Court in O, setting out the general approach to statutory interpretation, and then at the end of paragraph 42 over the page, Lord Justice Popplewell says this applies as much to statutory instruments as it does to primary legislation, and the relevant paragraphs are paragraphs 43 and 44. 43, where a meaning is not set out expressly in the wording of the instrument, that meaning may nevertheless sometimes be implied. However, where the instrument is silent, the implication must be a necessary one, not merely reasonable or desirable. This is well established by authority. Then after the citations just above letter D, the test is one of necessity, and what this means is that the implication must be compellingly clear. Paragraph 44. One reason for such an approach is that it is a relevant factor against making the implication if it would have been easy enough for the instrument to have said it expressly, but did not do so. This is not a sufficient test in itself, but it means that, as Lord Justice Underhill put it in Oppedina and Chicale, it is a healthy principle that courts should be slow to give a statute an effect that is not expressly stated. Parliament should say what it means. So those are the principles. Applying these principles to this case, it's, in my submission, very hard to see how there could be a necessary, compellingly clear implication from the terms of section 49, subsection 1, that the interest in possession beneficiary is treated as having incurred the trust liabilities. It clearly doesn't follow as a matter of logic. If I am beneficially entitled to certain property, that does not entail that I have incurred the liabilities incurred by the legal owner of that property. There's not much I can say by way of elaboration on that submission. It just doesn't follow. Furthermore, if that is what Parliament actually meant, it would have been perfectly easy for Parliament to have said so expressly.
And also, you've got to look at the purpose of Section 49. Section 49(1) is designed to ensure that if somebody retains a beneficial interest, they are not treated as if they've got rid of their interest in the land. In other words, it comes in for the purposes of inheritance tax. That's what it's driving at. And it can't, therefore, be a necessary implication of that. Liabilities have got nothing to do with that. It's bringing the property within the estate, isn't it?
That's right, Melody.
That's what it's after.
That is effectively what the Upper Tribunal said.
Yes.
The purpose of section 49, subsection 1, is to include property in the beneficiary's estate. It's not required in order to fulfil that purpose that it make any particular provision as to liabilities. And
that begs the question of what is meant by property and whether Mr. Justice Mann was right in the way in which he approached it. And also the mechanism by which, as everybody seems to assume in normal cases, one knocks off the liabilities in order to get to the value which is susceptible to the inheritance tax.
Yes, yes, but I've got to come on to all of that. But for the moment, the point I'm making is it's very hard to see how, on any ordinary basis, it could be said to be a necessary implication. For what it's worth, as an example of Parliament saying so expressly, we can look at Section 60 of the Taxation of Chargeable Gains Act 1992, which is at page 62 of the authorities bundle. May I just show the court that very briefly?
So that's
This is page 62, and it's section 60, which starts at the bottom.
the bottom.
Okay.
Yep.
And it says, in relation to property held by a person as nominee for another person, or as trustee for another person absolutely entitled, as against the trustee, or for any person who would be so entitled, but for, etc., etc. At the top of page 63, this act shall apply as if the property were vested in, and the acts of the nominee or trustee in relation to the property were the acts of the person or persons for whom he is the nominee or trustee. It's a different statute, it's a different tax, but the point I'm making is this is an example of Parliament deeming the beneficiary not only to stand in the trustee's shoes as regards ownership, but also as regards actions taken by the trustee in relation to the property. It's not hard for Parliament to do this if it wants to.
The important point is Section 49 is absolutely silent on this.
Yes, that's my submission. So in light of all of that, how did anyone, in this case, ever think that there was an implication in Section 49, subsection 1, that the interest in possession beneficiary is deemed to have incurred the trust liabilities? The FTT's reasoning on this subject, which is now adopted by the Revenue, is at paragraph 228 of its decision, which is at page 276 of the core bundle. My learned friend Mr. Davies showed it to you yesterday. And I think what the FTT was saying there is this. This is my summary of what I believe the reasoning is. I'm not quoting it. I think the FTT was saying, well, on the one hand, we know that the interest in possession beneficiary is deemed to be beneficially entitled to the settled property. And on the other hand, we also know, because it's common ground, that one way or another, the trust liabilities are brought into account in determining the value of that property. And then the FTT poses the question, who is deemed to have incurred these liabilities, if not the interest in possession beneficiary? To which, of course, the answer is no one. But I think the question the FTT is really posing is, if Section 49, subsection 1, doesn't deem the beneficiary to have incurred the trust liabilities, how do you ever take trust liabilities into account at all? That is not a question which it is strictly necessary for this court to answer in order to decide this appeal. As far as I'm concerned, a reasonable answer to the question would be, well, I don't know, but it's not Section 49, because that's not what it says. And that is, in effect, the answer the UT. The Upper Tribunal did not find it necessary to go into this wider underlying question of what is the statutory basis for bringing trust liabilities into account in the first place.
Well, it's not terribly satisfactory to leave it hanging in the air, though, is it?
Quite right, my lady. In fact, I was just about to say, lest it be thought that that's not an intellectually satisfying answer, I have, of course, made some submissions on this general question. They're the same submissions as I made below, and those are in my skeleton argument at paragraphs 7 to 11. The starting point in addressing this question is the general law as to trust liabilities and the trustee's right of indemnity. And for that, I rely on the Privy Council's decision in Equity Trust and Halabi, which is tab 43, page 782 of the authorities bundle. This was a case concerning claims by former trustees for an indemnity in circumstances where the trusts in question could colloquially be described as insolvent. That is to say, where the aggregate of the liabilities incurred by the former and present trustees exceeded the value of the property in the trust fund. The issues are summarised in the second paragraph of Lord Reed's judgment, that is page 787, where his lordship says the principal issues can be summarised as follows. 1. Does the right of indemnity confer on the trustee a proprietary interest in the trust assets? 2. If so, does the proprietary interest of the trustee survive the transfer of the trust assets to a successor trustee? 3. If so, does a former trustee's proprietary interest in the trust assets take priority over the equivalent interests of successor trustees? And 4. Does a trustee's indemnity extend to the costs of proving its claim against the trust if the trust is, quote, insolvent, in the sense that the trustee's claims to indemnity exceed the value of the trust fund? The Privy Council unanimously answered questions 1, 2 and 4 yes, and by a 4-3 majority answered question 3 no. Fortunately for my purposes, I'm only really concerned with question 1. And these maybe then move on to paragraph 56 in the judgment of Lord Richards and Sir Nicholas Patten, with whom on this point everybody else agreed. The paragraph 56 is page 798, the authorities bundle. And paragraph 56 simply describes what the trustee's right of indemnity is. The right of indemnity entitles the trustee both to be reimbursed for any liabilities properly incurred in the execution of the trust, which it has paid from its own resources, and to pay or seek payment of such liabilities from the trust assets without first making payment out of its own resources. These two aspects of the right of indemnity are commonly described as a right of reimbursement or recoupment and a right of exoneration. And then at paragraph 58, they explain that the need for the right arises because in English law, a trustee is personally liable for all debts and obligations incurred by it in the course of acting as a trustee. Its liability is no different from its liability for debts incurred for its personal benefit. This necessarily follows from the nature of a trust in English law.
Is the right confined to a right to reimbursement out of the value of the property, or is there any right over against the beneficiary?
That's actually dealt with at paragraph 63, my lady. The right of indemnity does not impose any personal liability on any person, neither the beneficiaries, except in the case of a trust where all of the beneficiaries are sui juris and the liabilities are incurred with the consent of the beneficiaries, neither the beneficiaries nor any successor trustees are under any personal liability.
I asked you that question because I'm interested in section 5.3.
Yes.
Yes.
I know what the point is that you make about section 162.
Yes.
But just playing devil's advocate for the moment, his liabilities, in certain circumstances, which we just looked at, might be regarded as a liability to reimburse the trustee.
Yes, in some circumstances. Yes.
And those liabilities would be taken into account except as provided by this Act.
Yes.
It might be said that if that door is opened so that those liabilities are, if you like, brought into the overall scheme, that sheds light on the scope of section 49.1. Because I'm just stretching it at the moment, but I'm looking at it through the revenue's eyes. If one's looking at the overall position, 49.1 says nothing about putting somebody into the position of a trustee, but 5.3 might actually make those liabilities relevant to valuing what goes into the estate.
In the case of a beneficiary absolutely entitled against the trustee who is of full age and capacity, then you might say, well, the trustee has a right of indemnity, a personal right of indemnity against that beneficiary.
Yeah.
And you might describe that as, quote, his, i.e., the beneficiary's liability. Yeah. I can see that.
But you say it doesn't make any difference to the way one looks at section 49.
No. And also,
you say it doesn't apply here.
No, it doesn't apply here, and it certainly doesn't. It doesn't explain more than a small minority of cases in which trust liabilities need to be brought into account. Then moving on to paragraph 70. This is where the consideration of issue 1 begins. We turn now to consider the first principle submission of the appellants, that the right of indemnity is a purely personal right, and that a trustee's lien is no more than a possessory right, entitling the trustee to retain trust assets, pending satisfaction of its indemnity, while the trustee remains the legal owner of those assets. In many of the English authorities, it is said that the trustee's right of indemnity involves or is supported by a lien or charge over the trust fund. It is well established that although the word lien is used both at common law and in equity, it connotes very different rights. A lien at common law is possessory and does no more than entitle the lien holder to retain possession of the assets in its possession. An equitable lien does not depend on possession, but entitles the lien holder to have the property over which the lien exists applied in discharge of amounts due to the lien holder. Because this right is enforceable in equity, the lien gives the lien holder a proprietary interest in the relevant property, where its purpose is to secure a debt due to the lien holder, as for example in the case of an unpaid vendor's lien. It is in effect a charge, but one arising by operation of law rather than consensually between the parties. In Gavin Edmondson's Solicitors, a case concerning a solicitor's equitable lien over the proceeds of successful litigation, Lord Briggs said, Barker and St Quintin shows better than any other case, I suppose, that the equitable lien operates by way of security or charge. And then at paragraphs 74, 75, and 76, there are further citations of authority to the same effect about the nature of an equitable lien. Then at paragraph 77, their lordships say, as the word lien has repeatedly been used by equity judges in relation to the equitable right of indemnity enjoyed by trustees, it may be thought likely that the judges were using lien in a way consistent with its use in equity. This is only strengthened by the use of charge as an alternative description, which likewise, because it is enforceable in equity, confers on the chargee a proprietary interest in the charged property. So the point being made here is that the submission of the appellants, i.e. that when the cases talk about the trustee's lien, they mean lien in the common law sense, is on the face of it not very plausible, given that they're all equity cases decided by equity judges. They then go on to consider a number of other English authorities, but we can skip to paragraph 94, I think, on page 805. Where they say, the English courts have not explicitly addressed the question whether the trustee's equitable right of indemnity gives the trustee a proprietary interest in the trust property over which the right exists. Nonetheless, we consider that the analysis in the authorities that the right confers or constitutes a charge or lien over that property, enforceable by a court of equity, leads inevitably to the conclusion that it does create a proprietary interest in favour of the trustee. Then from paragraph 95 there's discussion of the Australian authorities, and the conclusion on issue 1 comes at paragraph 105 on page 806. As regards the first main issue on these appeals, we conclude that the right of indemnity confers a proprietary interest in the trust property in favour of the trustee. The English and Australian authorities are inconsistent with the appellant's contention that equity confers no more than a possessory lien enjoyed for so long as the trustee retains trust assets. There is no doubt that a trustee is entitled to apply or to seek an order of the court to apply trust assets in its possession in payment of amounts due under its right of indemnity, and that a trustee is or may be entitled to retain sufficient assets or require security before a transfer to a new trustee. Those rights are not, however, inconsistent with a charge over and proprietary interest in the trust assets, but are practical means by which such charge or interest may be enforced or protected. So once one appreciates that the trustee's right of indemnity leads to the trustee having an equitable proprietary interest in the trust property in the nature of an equitable charge, the question, why are trust liabilities taken into account for inheritance tax purposes, almost answers itself. Because if I'm beneficially entitled to certain property and someone else has a charge over that property, then when the Act tells you, for the purposes of the deemed transfer of value on my death, to calculate the value of the aggregate of the property to which I'm beneficially entitled, it seems pretty obvious that that value ought to be the value net of charges. And that does not depend on me, in my example, on me being deemed to have incurred any particular liabilities. The reason is just that someone else has a charge over some of my property, and of course that goes to value.
Well, take the standard example of a mortgage. Somebody dies, their property is subject to a mortgage.
Yes, quite right. Yeah. But my submission is the Inheritance Tax Act does not leave you to work that out for yourself. It makes express provision to that effect, and that is in section 162, subsection 4.
which is in the part of the Act dealing with valuation.
Yes,
where you
precisely.
expect to find it.
It's in the part of the Act dealing with valuation, and it's in a section headed liabilities.
Two quite useful clues.
Yes. Anyway, section 162, subsection 4 is page 40 of the authorities bundle. It deals expressly with liabilities which are encumbrances on any property, and it tells you expressly and in mandatory terms what to do about such liabilities as far as value is concerned. Shall be taken to reduce the value of that property. Now, my learned friend said that there is somehow some prior step before you get to section 162, subsection 4. You have to show that the liability is brought into account for some other reason, and then section 162, subsection 4 simply tells you to set it against some assets rather than others. Obviously, I accept that part of the purpose of 1624 is to tell you that liabilities of this type reduce the value of specific property, but I don't understand the idea that you have to look elsewhere for the proposition that encumbrances reduce the value of the property they're charged on for inheritance tax purposes. As I said, the subsection is mandatory. It doesn't. It says a liability which is an encumbrance on any property shall be taken to reduce the value of that property. There's no other way to read it, and indeed one could contrast the immediately following subsection 5, which is talking about liabilities owed to non-residents. And there it says, where a liability taken into account is a liability to a person resident outside the United Kingdom, etc., etc. So that perhaps is an example of a provision which assumes that the liability is already taken into account by virtue of some other provision elsewhere in the Act. But that's not the way that subsection 4 is drafted.
Is there a definition of encumbrances anywhere, or is it just left for one?
I might be one in.
I think not, but if there is.
I don't think there is one. Let me just check. There isn't one in section 272. Oh, yes. Well, there's an inclusive definition.
Okay, thank you.
Where it says encumbrance includes any heritable security or other debt or payment secured upon heritage. I think that's one of those provisions that just bring in Scottish law.
It sounds a bit north of the border.
Yeah. But in any event, it's common ground, and has been common ground all the way through this case, that the trustees' lien, the life trustees' lien, is an encumbrance within the meaning of the Act. Was an encumbrance.
Yeah, and to state another obvious point, the fact that one of the two trustees, Mrs Elborne herself, is neither here nor there. The step was taken by them together wearing their trustee hats.
I respectfully agree. Yes. Anyway, that to the extent anyone needs one, is my explanation of why trust liabilities are brought into account and the statutory basis for it. I think to the extent one is addressing this question, it's very important to bear in mind that the case of qualifying interests in possession is really only a minor part of the circumstances in which this question arises. Much more significant, certainly since 2006, are relevant property trusts, trusts in which no qualifying interest in possession subsists. And may I just very briefly show the court the provisions about those? So, Section 58, which is at page 35, defines relevant property as settled property in which no qualifying interest in possession subsists, other than various exceptions. And since the Finance Act 2006, virtually no interest in possession created by an inter vivos settlement is qualifying. So this now describes most trusts created after 2006. Then the primary charge is under section 64, page 37. Where immediately before a 10-year anniversary, all or any part of the property comprised in a settlement is relevant property, i.e. is settled property in which no qualifying interest in possession subsists, tax shall be charged at the rate applicable under sections 66 and 67 below on the value of the property or part at that time. So precisely the same question arises if the trustees of a relevant property trust hold trust assets worth 100, but have incurred liabilities of 80. Again, everyone assumes, everyone agrees it must be right that the value charged under section 64 is 20 rather than 100. But section 49 can't possibly help you with that question because it only applies to settled property in which a qualifying interest in possession does subsist. Whereas in my submission, section 162, subsection 4, applies across the board. If one is looking for an answer to the general question, one should look for an answer which applies generally. To summarise where I've got to so far, section 49, subsection 1 does not deem the beneficiary to have incurred the trust liabilities. That isn't a necessary implication of the provision in any ordinary sense. It's not required in order to explain why trust liabilities are brought into account. And as an explanation of why trust liabilities are brought into account, it's a pretty bad one because it only covers some types of trust. I haven't yet said anything about St Barb Green, and I should turn to that now.
Sorry, just before you do that,
Yes,
are you also going to deal at some point with the question of reliance placed upon the Fowler deeming principles as a
Well, I can
another route to the same conclusion?
Well, may I deal with that now then?
I thought it might come in helpfully at this point, it seems, because I take it you'll say that the consequences are not inevitable, just in the same way that they're not unnecessary.
Exactly, my lord.
That's really the end of the point.
That's it. And of course, that in the construction of any deeming provision, there are two types of question one can ask. The one that usually takes up attention is how far does one take the consequences of the deeming? But we're concerned in this case with the prior question of what actually is the deeming.
Yes.
Yeah.
But yes, in summary, I say it's not an inevitable consequence for the same reason it's not a necessary implication.
So, St Barb.
Yes, so I said so far I haven't said anything about St Barb Green. For reasons which are perfectly understandable, St Barb Green has probably taken up a disproportionate amount of attention in the tribunals below. And there are a number of reasons why that is. One reason is that Mr Justice Mann's use of the expression net property was very heavily relied on by HMRC, at least in the FTT, in relation to the argument about section 102, subsection 3. From listening to Ms Belgrano's submissions this morning, it doesn't seem that it is relied on in that regard.
It's possibly
anymore.
because her leader says that it's wrong.
That would be a good reason. But at any rate, it was very heavily relied on in the written submissions before the FTT. So from my point of view, the main reason why I needed to refer to it was to explain why it didn't say what revenue said it said. And the other reason, of course, is that it's the only case which even touches on this question about trust liabilities. And it is, of course, perfectly reasonable for the FTT and indeed the Upper Tribunal to get what, to derive what guidance it can from a decision of the High Court. The problem is that St Barb Green is not a case about why trust liabilities are brought into account. And the part of the decision that touches on the point really consists of a single sentence by way of obiter dictum stated by Mr Justice Mann on his way to a conclusion about something else. And then just for good measure, the reasoning in support of that conclusion that he's on the way to is with respect, actually quite difficult. That's the paragraph 12 reasoning as opposed to the paragraph 13 reasoning. The conclusion that Mr Justice Mann is working his way towards is that section 5, subsection 3, which on the face of it tells you that a person's liabilities shall be brought into account, is not actually the source of the right to bring a person's liabilities into account. So it's, on top of everything else, it's even what it is saying is difficult. Right. So I should say, what if anything, do I rely on St Barb Green for? Well, first of all, I rely on it for the result, because everybody agrees that the result in St Barb Green, i.e. that you cannot set the deceased's personal liabilities against the value of the settled property, is correct. Everyone agrees that's correct, whether it's on the paragraph 13 basis or the paragraph 12 basis. And I say that result, which everyone agrees is correct, is completely inconsistent with the idea that the interest in possession beneficiary is deemed to have incurred the trust liabilities, so that they are, quote, his liabilities within section 5, subsection 3.
It's the reverse situation.
Yes. If that were the case, it's very hard to see how the taxpayer's argument in St Barb Green could possibly have been resisted.
Exactly.
Because what the taxpayer said is, look, I've got an estate, or the deceased has an estate. Section 49 tells you the trust property is part of the estate, and then section 5 subsection 3 tells you you can deduct his liabilities in determining the value of the estate. So what's the problem? If on top of that, the deceased were also deemed personally to have incurred the trust liabilities, so that those liabilities were his liabilities in terms of section 5, subsection 3, it's very hard to see how the argument of the taxpayers in that case could possibly be wrong. So that's my main submission on St. Mark Green. The other submission is that what Mr. Justice Mann said in the one sentence worth of obiter dictum is consistent with my explanation of why trust liabilities are brought into account. Although frankly, in common with my learned friends, I would probably say that if it isn't consistent with my explanation, then it's wrong.
Perhaps also, is it worth remembering that, and it's only really very recently that the law on the trustee lien was clarified and authoritatively stated in the Investec case. And before then, it was, perhaps a degree to which there was something in the point that how to deal with liabilities is really a question which the inheritance tax legislation tends to skirt around rather than confront and provide a clear answer to.
Yes, that's absolutely right, my lord. And of course, I'm not criticising Mr. Justice Mann.
No, I mean absolutely, because it was, and indeed he ended up endorsing what the Revenue had always said, I think, which was that the best guide you can find is Section 5, subsection 3.
That's right. But I suppose that leads into one final point before I go on to property derived from, which is that this question of on what basis are trust liabilities brought into account, it is a question of general importance. You have to give the same answer to the question whether you're asking it because you want to know about Section 103 or whether you're asking it for any other purpose. And it's a question which in general terms has not always been regarded as easy, on which there's no existing authority, so whatever this court says will be the authority on the question. And it can't, what the Revenue are really inviting you to do is to start with Section 103 and then give an entirely novel and unsatisfactory answer to the question about why trust liabilities are brought into account, so that the facts of this case can somehow be squeezed within Section 103. And that, of course, is an invitation which I submit this court should reject. Now, if I'm wrong about all of that, we go on to the second question, whether the consideration was property derived from Mrs. Elborne within the meaning of sections 103(1)(a) and 103(3). And this certainly is a question about the construction of section 103, and to me at least, it's probably the most difficult single point in this appeal. The reason it's difficult is because Section 103 is a very densely drafted, intricate provision, which, if we get to this stage of the argument, we are then trying to apply to a notional transaction in which Mrs. Elborne is borrowing money from herself. So it's not surprising it's difficult. In my submission, it's absolutely critical to understand how Section 103 operates as a whole before going on to address the particular point of dispute between the parties in this case. And the place to start is to have some understanding of what Section 103 is aimed at. Not because that's determinative of construction, but because it, to me at least, it makes the section a lot easier to understand if you've got some idea of what it's trying to do. At paragraph 14.1 of my skeleton argument, I've referred to a number of different statements of a mischief, including in textbooks, and a judicial statement of what mischief is in McDougall's Trustees. I think I'm just going to take the court to the relevant passage of the Revenue's Inheritance Tax Manual, just because I think it expresses the point most simply. Should I do that now or...
I think if you just do that, and then
Yes.
we'll break.
So that is, hopefully it's at... Sorry, let me find the tab. Right. Within tab 55 of the authorities bundle, there should be a page 1207.
Yes.
And may I just invite the court to read the words under "this provision would defeat the following arrangement." So this is what section 103 is aimed at. A gives money to B, B then lends the money back to A, and then the manual explains what the problem with that is from the point of view of inheritance tax.
And I think what is said in that bit of the manual sort of updates what was anyway identified by Lord Patrick in the McDougall.
That's right, my lord. Yes.
Because he expressly gives the example of a gift and an immediate loan back.
That's right. It's
It's rather a dense case to wade one's
Yes.
way through. But
yes. But the description of the mischief is, as your lordship says, the estate duty version of the description given.
yeah. And of course we must not treat that as an exhaustive statement
No,
necessarily. And quite rightly we were told it's an anti-avoidance section, so we must see where it takes us with that in mind. Whereas perhaps fair to say section 103 has always existed in something of a backwater compared with 102, certainly.
There's the only
Very little
authority.
guidance on it.
Sorry,
There's very little in the way of
There's-
judicial guidance on it.
there's only really one authority, which is McDougall's.
That's the only one, is it?
There's a special commissioner's decision called Fazakali, but that in that case it was common ground that section 103 applied, unless the first disposition in the chain avoided being a transfer of value by virtue of being a disposition for the maintenance of family. So that's a case which is really about dispositions for maintenance of family, hence why it's not cited by anyone.
Thank you. Is that a convenient moment?
It is.
2 o'clock then. Thank you.
All right, if able.